A woman in Ohio walked into a hospital for a 45-minute outpatient procedure. Routine. Scheduled weeks in advance. She signed every form the front desk handed her. 6 weeks later, a bill for $23,000 showed up in her mailbox. When she called to dispute it, the hospital told her she had signed a document agreeing to all charges at the time of service. She had. She just did not know what she was agreeing to. And she is not alone. Up to 80% of hospital bills in America contain at least one error. Duplicate charges. Procedures billed twice. Services that were canceled but never removed. And the average overcharge on a bill over $10,000 is $1,300. But here is what nobody tells you. There are 5 words you can say before you sign a single document at any hospital. And those 5 words activate a set of legal protections most patients do not know they have. 5 words that force the hospital to show you numbers before you agree to anything. 5 words that could save you thousands. And in some cases, eliminate your bill entirely. Those 5 words are, I need a price first. Stay with me. By the end of this, you will understand exactly why those 5 words change everything. What federal laws back you up when you say them. And the one hospital program that erases bills for households earning up to 6 figures. Most people never hear about it because the hospital is not required to bring it up. You have to ask. What happens the moment you say those 5 words? When you walk into a hospital for any scheduled or an emergency procedure and say, I need a price first, you are activating your rights under a federal law called the No Surprises Act. This law, which took effect in January of 2022, requires every healthcare provider and facility in the country to give you something called a good faith estimate before you receive an emergency care. Not after. Before. This estimate must include the total expected cost of the procedure, including hospital fees, medical tests, lab work, imaging, anesthesia, prescription drugs, and equipment. It must be provided to you in writing at least 1 business day before the scheduled service. And if the final bill exceeds that estimate by $400 or more, you have the legal right to formally dispute it through a federal arbitration process. The cost to initiate that dispute is $25. That is it. Think about what this means. If you are given an estimate of $6,000 for a procedure and the bill comes back at $7,000, you can dispute the difference. A certified third-party arbiter reviews the case and decides what you actually owe. The hospital does not get the final word. But here is the critical detail. This protection only activates if you ask. If you sign every document without requesting an estimate, you are agreeing to open-ended charges. The moment you say those 5 words, the hospital must produce numbers, and those numbers become your legal baseline. The form they hand you that most people never read. Every hospital admission involves paperwork. Most of it looks routine. You sign your name. You initial the boxes. You hand over your insurance card. What most patients do not realize is that buried in those forms is a document that may ask you to waive your federal billing protections. Under the No Surprises Act, out-of-network providers in emergency situations can ask you to sign a written consent form that waives your right to balanced billing protection. If you sign it, you are agreeing to pay whatever that provider charges, even if it is dramatically higher than what your insurance would have covered. Here is what you need to know. You can refuse to sign that waiver. The law does not require you to agree. And in the majority of situations where surprise billing is most common, including emergency care, anesthesiology, pathology, radiology, laboratory work, and hospitalist services, the provider is not even allowed to ask you to waive your rights. The waiver option only exists in a narrow set of NO and emergency scenarios where you had the ability to choose your provider in advance. If a hospital hands you a consent form and you are not sure whether it contains a billing waiver, say this: does this form waive any of my billing protections under the No Surprises Act? If the answer is yes, you can decline it and still receive care. In emergency situations, the law protects you automatically. No form required. No consent needed. The hospital cannot bill you more than your in-network cost-sharing amount, regardless of whether the provider who treated you was in your network or not. The hospital program that can erase your bill. And why they do not mention it. Roughly 60% of hospitals in the United States are classified as nonprofit. They operate under a federal tax-exempt status granted by the IRS under Section 501(c)(3), in exchange for paying zero corporate income tax. These hospitals are legally required to maintain a financial assistance policy, sometimes called charity care. This is not a government welfare program. It is a condition of the hospital's tax-exempt status under the Affordable Care Act. Every qualifying nonprofit hospital must publish this policy in writing, make it available on their website, and provide it to any patient who asks. Here is what most of these policies look like. If your household income falls below 200% of the federal poverty level, which for a single person in 2026 is roughly $31,200, and for a family of 4 is approximately $66,000. You may qualify for a complete write-off. 100% of the bill. Eliminated. If your income is between 200 and 400% of the poverty level, which for a family of 4 means up to roughly $124,800. You may still qualify for a significant discount, often 50 to 75% off the total charges. Some large hospital systems, including major academic medical centers, set their thresholds even higher. And here is the part that changes everything for people who think it is too late. You can apply for financial assistance after you have already received the bill. In most cases, you have up to 240 days from the date of the first billing statement to submit an application, even if the bill has already been sent to collections. Some hospitals will still process a financial assistance application. The hospital is required by federal law to have this program, but they are not required to tell you about it at the front desk. You have to ask. And the question is simple. Do you have a financial assistance application? How to check your bill for errors before you pay a single dollar. You received the bill. Now what? Before you pay anything, you need to do one thing. Pick up the phone, call the billing department, and say, I would like a fully itemized statement. Not a summary, not a total, a line-by-line breakdown of every charge, every procedure code, every supply, every medication, and every fee. Federal law gives you the right to this document, and it is the single most effective tool you have for identifying overcharges. Once you have the itemized statement, look for 5 specific problems. First, duplicate charges. The same procedure or supply listed twice on the same date. This is the most common billing error. appearing in roughly 1 out of every 4 incorrect bills. Second, charges for canceled services. If a test was ordered but never performed, or a procedure was scheduled but did not happen, it may still appear on your bill. Third, upcoding. This occurs when a routine service is billed as a more complex or expensive procedure. A standard office visit coded as a comprehensive evaluation. A basic lab panel billed as an advanced diagnostic workup. Fourth, unbundling. This is when a hospital separates a group of services that should be billed together under a single code and instead bills each component individually at a higher total cost. Fifth, incorrect quantities. Being billed for 10 units of a medication when you only received 2. Being charged for 5 days in a room when you were discharged after 3. If you identify any of these errors, call the billing department and request a correction. If they refuse, you have the right to file a formal dispute. For surprise bills specifically, the No Surprises Act gives you access to federal arbitration. For other billing disputes, your state's Attorney General office or insurance commissioner can intervene. And here is one final number that should motivate you to check. 74% of patients who dispute a billing error get it corrected, but only 2% of patients ever make the call. The system is designed for people who do not question the numbers. Do not be one of them. Your action plan before any hospital visit. Before you go in, do these 4 things. 1. Say the 5 words. I need a price first. Get your good faith estimate in writing. Photograph it. Save it. This is your legal baseline if the final bill is inflated. 2. Read every form before you sign. If anything mentions waiving billing protections or agreeing to out-of-network charges, ask what it means. You have the right to decline. 3. Ask whether the hospital is a nonprofit. If it is, ask for the financial assistance application. You may qualify for a full or partial write-off and not know it until you check. 4. After any visit, request an itemized statement. Compare it to your good faith estimate. Look for duplicates, canceled services, upcoding, unbundling, and quantity errors. If something does not match, dispute it. 5 words. That is where it starts. I need a price first. The law is on your side. The protections exist. The only thing missing is you using them. Share this with someone who has a hospital visit coming up. One conversation could save them thousands.